Hello, everyone. I'm attorney Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about what is a devisee in my estate plan. Now, if you're thinking about creating an estate plan, you may hear some new and confusing terms that kind of make your brain hurt. Now, to add to your bewilderment, not only are some of the words unfamiliar, they may also be homophones, words that are pronounced the same as other words but have different meanings and spellings. For an example, an heir, H-E-I-R, is a person who legally, under a will or according to state law, receives money or property from another person when that person dies. In contrast, air, A-I-R, is an invisible gaseous substance made up primarily of oxygen and nitrogen that surrounds the earth. The two words sound alike, but obviously have vastly different meanings. Likewise, if you've heard an estate planning attorney mention a devisee, it is very different from a device, which usually refers to a piece of electronic or mechanical equipment. So exactly what is a devisee in your estate plan? A devisee is a legal term that traditionally has referred to a gift of real estate made by a will. However, in common usage, it has been used interchangeably with other legal terms such as bequest, which traditionally refers to a gift made in a will of personal property, that is, property other than real estate. Now, courts will uphold the use of either term for a gift of real or personal property in a will if the will clearly shows that the person who created it, that being the will maker, intended to make that gift. Now, there are several different types of devisees. There's general, there's specific, demonstrative, and residuary. The distinction between them is important, so we'll provide a definition of each type. So let's start first. A general devisee or general bequest is a gift made in a will that does not direct the transfer of a specific piece of property, but rather is a gift of a specified quantity or value that is to be made from any property of the same general type that is part of the will maker's estate. So for example, if Ward wanted to leave his sons Beaver and Wally each a gift of $10,000, those gifts are general devisees, and the executor of Ward's estate may pay out those gifts from any account or other source of funds that Ward owns. Next, let's talk about a specific devisee or specific bequest, and that's a gift made in a will of a particular account, parcel of real estate, or other item that the will maker intends for a beneficiary to receive. The executor may only satisfy a specific devisee by delivering that exact account or other item. The gift may not be made from any other accounts or items in the will maker's estate, even if the specific amount mentioned no longer contains any funds or the item has been sold or destroyed. For example, if Fred's will specifies that his Canoposaurus Flintmobile is devised to his daughter Pebbles, the executor can satisfy the specific devisee only by transferring that exact vehicle to Pebbles. Now let's talk about a demonstrative devisee or bequest. That has elements of both general and specific devisees because it is a general gift, but the will specifies that it is payable from a specified fund or source of property. For example, if Mario's will specifies that he leaves his brother Luigi a gift of $25,000, but also directs that the gift should be made from the funds in Mario's Bank of Mushroom Kingdom savings account, he has made a demonstrative devisee. Similarly, if Mario's will provides Luigi a gift of any 3 plungers in Mario's extensive plunger collection, that is also a demonstrative devisee. And lastly, let's talk about a residuary devisee. And that's a gift of all property or money that remains in an estate after all of those specific, general, and demonstrative devises have been made and all expenses, debts, taxes, and any other obligations of the estate have been paid. Typically, a will includes a residuary clause naming a beneficiary who will receive any remaining money or property to ensure that nothing, even property the will maker has forgotten that they own, will pass according to the state's default laws. which may not reflect the wishes of the will maker. For example, let's just say that Lord Grantham's will contains a residuary clause stating, I give all the residue of my estate to my third cousin once removed, Matthew Crawley. If Matthew Crawley does not survive me, I give all the residue of my estate to my unacknowledged son, Thomas Barrow. You might be surprised to learn that the type of devisee has very significant implications. A legal concept called redemption refers to the withdrawal or nullification of a gift made by a will because the property identified in the will is no longer in the will maker's estate. Redemption does not apply to general or demonstrative devises. However, it does apply to specific devises where the property described in a will is no longer in the will maker's estate when they die. It does not matter whether the property was intentionally or unintentionally removed from the estate. For example, if that flipmobile is stolen and never recovered, it will obviously be impossible for Pebbles to receive it as part of her inheritance. Now, in some states, the law does not permit the substitution of other property to replace the specific devisee that is no longer available. So if that flipmobile was a substantial part of Pebbles' inheritance, she may receive much less than Fred actually intended. Fortunately, some states have non-redemption statutes that provide certain exemptions so that, in our example, Pebbles could receive insurance proceeds that have not yet been paid to Fred at his death because that flipmobile was totaled in an accident, or receive the unpaid proceeds if Fred sold the vehicle to Bernie but had not yet received the amount owed before his death. Another situation in which the type of devisee matters is when an estate is not large enough to cover all of the gifts made by the will, administrative expenses, creditor claims, and other obligations that it may owe. Under the law, the doctrine of abatement determines the order in which types of devisees are reduced or even eliminated, depending on the circumstances. Generally, the residuary devise is reduced first, and then general devises, then demonstrative devises, and lastly, specific. This amounts to a presumption under the law that the highest priority of an estate is to make specific devisees, and that the other types of devisees are a progressively lower priority. So if after administrative expenses, creditors' claims, and other obligations are paid, Fred's flipmobile is the only property left in the estate, then Pebbles will receive her inheritance, but no other beneficiaries named in Fred's will would receive an inheritance, not even if that was not his intention. So let us help you devise an estate plan that achieves your goals. So yes, the word device, has yet another meaning that conveys the idea of carefully planning something out. So if you live in Mass or New Hampshire, we're happy to help you devise an estate plan that will ensure all of your loved ones will receive the money and property that you wish to leave them in the amounts that you intended. So I want to thank you for watching. I'm attorney Kelly Longtin, founder of Kelly Longtin Law. We provide effective estate planning for everyday families.